ended a 2-hour emergency meeting on the subject just 26 minutes after it began.
What a shame.
What a shame. Cover up. Cover up.
No, it's a cover-up.
You can hear them shouting as the Liberals blocked a bid to bring in Jody Wilson-Raybould to testify a second time. Opposition MPs call the move, as you heard, a cover-up. But the Liberals say there will be a regularly scheduled meeting next Tuesday. That meeting, however, will be behind closed doors. It also happens to be on the same day as the budget. This hour, not only are we live right here on CBC News Network, as we always are, so hello to you, but you can also watch us on our social media channels. So for those of you who are joining us on Facebook and YouTube and Twitter, great to have you. We would like you to join in on the conversation we're about to have on the SNC-Lavalin affair. This is an opportunity for us to talk together. Usually it's me talking, hopefully not at you, but with you. But this is, your chance to talk to me too. So you can head over to CBC News Facebook page. That's at facebook.com/CBC News. And you can leave your questions in the comments. So there's one option. Or you can leave them in the chat if you are watching us on YouTube. So that would be at youtube.com/CBC News. We'll be monitoring all of our accounts, by the way. We'll get to as many of your questions as we can. And to help with that, I'm joined by a panel of 2 experts. In Montreal, we have Martin Patriquin. He is an author for iPolitics and the Montreal Gazette. So hello to you, Martin. How are you?
Great. How are you?
Excellent. Can't wait to hear those questions. Right here in Toronto, in studio, I have Lee Akazaki. He is a lawyer with Gilbertson Davis LLP. You ready for those questions?
Yes, I am. Thank you.
Great, because there are so many of them. As we watch right now, going into this conversation, I want to start with the most often asked question. You know what that is? Why did Gerald Butts resign? Martin, let me ask you on that.
Well, I think it's a sort of a combination, a couple of things. I think it's a bit of damage control, to sort of give an indication that this was having an effect on the Liberal government and that they wanted to get away from it a little bit. So there was that. There was probably also a little bit of Mr. Butts, having been at this job for a long time, just kind of got sick of it. I'm sure that's part of it. The other thing but the third thing I think is the more intriguing bit. If you listen to Trudeau's speech the other day, when he came and did that press conference, one of the things that he said was that there was an erosion of trust between the PMO and Jody Wilson-Raybould's office. And he specifically, not just the PMO, but he mentioned Gerald Butts specifically by name. And I can't help but wonder if it almost seemed a little bit like he'd thrown Gerald Butts under the bus a little bit. But that's my own personal take on it. But that maybe that had something to do with it as well. That if that relationship had soured and it was because of Mr. Butts, that perhaps that is why he sort of fell on his sword and left office. Left the PMO, pardon me.
Right, and you can see why that is our top question. But I want to get right now to Eric Combe. And Lee, this one I'd like you to come in on, because Eric wants to know, how do we get a public inquiry? Because he feels we need a nonpartisan review.
Well, there's a statute that provides for a public inquiry, and the government has to call for it.
Right, so it has to come from the Prime Minister's office.
That's right, and you recall that during the Martin government, there was a public inquiry with respect to the sponsorship issue. So it's something that can be called for, and the government can provide for it. And a public inquiry potentially would put an end to the Justice Committee hearings, because you really shouldn't have 2 at the same time.
One of the other questions that we're getting from our viewers on YouTube, and Martin, I want to bring you in on this as well, is that he says laws were not broken. So why does there need to be a public inquiry? And this comes from Sam on YouTube. Martin.
That's a very good question. As we well know, during the sponsorship scandal had that public inquiry specifically because rules were allegedly broken, and in fact, it came out that they were broken. That is exactly the case as to why perhaps the government has an argument against it. If you ask me, the cynic that I am, I would say that the government is looking at something like the sponsorship scandal and how much that blew up in the face of Paul Martin and Paul Martin's government. Specifically because it dragged it out for so long, right up until the election, and it demonstrably hurt Paul Martin. He lost the election. So I think that serves as a fairly large cautionary tale as to exactly why the Liberals would not call a public inquiry into this.
And there's a legal question as well. This comes from Andrew Johnson, and he asks this on Facebook. Lee, what are the actual legal constitutional issues the Prime Minister and others face? So, you know, you bring up constitutional issues here. A lot of eyes might glaze over, but let me know what the issues are.
Well, you know, one of the questions that's really important, and I think that the question addresses it, is what was it that was wrong, and what is the standard to which the PMO has to observe? And there's a very strong argument that no rules were broken, no laws were broken. The only issue that has really percolated to the top of this whole discussion is obstruction of justice. And in my view, under the criminal code, obstruction of justice, the case for it has not been made out, especially since we've heard from the former minister talking about the 10 or 11 meetings that she had, the people that came to see her. And if that is the extent of her evidence, I don't think that there is a case to be made for obstruction of justice. And if there hasn't been an obstruction of justice, then what else has there been? And I can't think of any legal reason for the alleged impropriety has to be with respect to a standard.
Right.
Is it a standard that we hold politicians to, but not ordinary citizens? Is it a you know, everyday discourse we have? If you have a guest over for dinner and they start shining their shoes on the table, that we say it's improper, impolite, but is it wrong in the sense of having done something that the public should be concerned about?
Right.
And if we're talking about a public inquiry, unless you can come up with a legal reason, such as a breach of a regulation, a violation of the criminal code, ethics issues, then there might not, very well might not be a need for a public inquiry.
Yeah, and just along those of what Lee just said, it's a very good point. During Jody Wilson-Raybould's testimony, you have to remember that she said that, you know, that what happened to her was she thought it was improper, that there was improper pressure put on her. But she made the specific point to say that, and I'm paraphrasing here, I don't remember exactly the words that she said, but that there was nothing illegal that happened. That's from a former, you know, the former justice minister herself. So from the mouths of babes almost, she herself said there was nothing illegal that happened.
Let me ask you, I want to move on to another issue, and this is the DPA, the Deferred Prosecution Agreement. We have talked about it. I had a guest on earlier, and we spoke about that at length. But this comes from Trina Bannatyne, who asks us on Facebook, could you give us insight into the future of business if the DPA was used? So if SNC-Lavalin was given that Deferred Prosecution Agreement and there was remediation, what message would that send to other businesses? Perhaps you could tackle this, Lee, and then I'll get to you, Martin, on it.
Right. Yep. In the criminal code, the DPA is called a remediation agreement.
Right.
An ability for a corporation to come forward having realized it's done something wrong and negotiate a sanction that falls short of being a criminal charge. This legislation came into effect in tandem with a statute called the Prevention of Corruption of Foreign Public Officials Act. So, big long name.
Yep.
But it was intended to bring Canada in step with a lot of OECD countries who have similar legislation, so that we couldn't have companies bribing public officials in Canada. But before then, it was okay for our companies to go out to other countries and commit what would be bribery in Canada. And in order to, and this was thought to be a prevention of these other countries from developing, because you continue to have dictators propped up, you had governments that were reliant upon graft. And so we have the legislation, but we also recognize through experience in the United States and the United Kingdom that these are very difficult statutes to enforce from a criminal prosecution perspective. And that's why we have a DPA system, so that we have corporate compliance without having to go through a lengthy trial, after which the Crown might very well lose.
Right. Now, that's the legal aspect of it. Martin, I want to bring you in on the political aspect of this, because it also optically looks different, doesn't it?
It certainly does, and Lee put the finger on the boo-boo there. He said that DPAs are remediation agreements, and it's important to say that they're called remediation agreements here in Canada. That the companies come forward to do this kind of thing. In the case of SNC-Lavalin, SNC-Lavalin didn't come forward. They were started to be investigated by the RCMP in 2015, so essentially they're in this position because they got caught, and it's an interesting position for them to be in, because they basically tried to lobby the government retroactively to get this law on the books so that it may apply to them. Nothing wrong with that. Lobbying is perfectly legal, but all the political implications that we're talking about that is a fallout from exactly what happened there. As far as DPAs are concerned in general, I mean, there is a danger, I think, that if you use it too often, or if you use it in a case with like SNC-Lavalin where they don't come forward, they get caught, that you can almost use a DPA or a remediation agreement as sort of cost of doing business. That you can go out and do all sorts of things and create sort of a moral hazard whereby, you know, you can bribe, you can do all sorts of things with foreign governments, and if you get caught, well, I'll just pay a fine.
Right.
And I think that's why the bar for these things, specifically in Canada as it applies to this case, are extremely high.
You know, there's an interesting question here, and it's just come in right now from Brian Lowry on YouTube, who wants to know this on the DPAs, and good for you, Brian, for, you know, knowing all about the DPAs, but he wants to know, how is a DPA not exactly like a regulated tax on bribery? So you kind of get your, you know, it might sound like a facetious question, but you kind of get your hand slapped. It's a good question.
It's a great question, but it speaks to exactly what I just said. Now, in the United States and Canada as well, in fact, these are, and Lee put his finger on it, as I said before. It is very much a situation where it's a proactive situation, where a company comes forward with information that it had done wrong.
Right.
Either by way of the board or a whistleblower or what have you within the company. That isn't the case with SNC-Lavalin. Again, they did not come forward with any of this. In fact, when they were charged in 2015, the first things out of the mouths of SNC-Lavalin lawyers with the charges having to do with Libya was, these charges have no merit. There was no demonstration on their part that they wanted to come forward with this information, that they were going to fight it to the nines.
I want to move from DPAs over to another topic right now, because I'm trying to get through as many. I mean, we love the fact that you're taking part in this, and therefore I want to respect your time that you're giving me by sending in your questions. This one comes from Wesley Davidson on Twitter, who asks, why is the Justice Committee not being open and transparent? That's a broad question. But here's the more specific one. And Lee, I'd like to direct this to you. If there is nothing to hide, why can't Trudeau waive the attorney-client privilege and allow Jody Wilson-Raybould to speak freely? Now, she was given a certain waiver.
Yes.
To speak in the time that she did appear before the committee. What else would be needed in order for her to talk about the shuffle?
Well, Jody Wilson-Raybould was in a difficult position, because you can't volunteer. The soliciting client privilege is a privilege that is enjoyed, in this case, by the government of Canada.
Who is the client?
That's right.
Yeah.
And it's no different from if a client came into my office for a family law issue or you know, a criminal matter or a civil dispute. Anything that is said to me for the purpose of obtaining advice and for the purpose of my being able to represent that person is going to be held secret unless the client says, please, you can divulge this information. And so from the outset, it was possible for the government, through the Prime Minister, to stand up and say that, you know, we waive privilege if there is a privilege. It doesn't mean that there was ever a privilege on the subject, on the discussions between the Prime Minister's office and Ms. Wilson-Raybould. That's a separate question altogether, but that could have been done away with by just saying, okay, we are not going to rely upon the privilege.
Right. So it has to come from the Prime Minister to waive that second part of the privilege to allow her to talk about the shuffle. Let me ask you, Martin, from a political perspective, why wouldn't Trudeau do that?
I mean, I think that sort of stems from the idea of giving Miss Wilson-Raybould a further platform. Politically right now, she's bulletproof. Everything that she says is being hung on, and is precisely because she comes off as very, very forthright, very, very credible, as we saw during her testimony. Why would a government, I mean, it's sort of why why God invented majority governments. It's like, why would the government, if this woman is doing harm to the Liberal brand, why would they allow her to speak further? Listen, and I'm going to say it to the viewers, that this is an extremely, extremely cynical position for any government to make. But it's cynicism that's sort of laid in time immemorial of governments in this country.
Right. You know, we're dealing, for viewers who are just joining us, what we're doing right now is taking questions from our viewers through Facebook, Twitter, YouTube, and posing them to this panel we have of great guests. We've got Lee Akazaki, who's a lawyer with Gilbertson Davis. He's right here in studio. In Montreal, we have Martin Patriquin. He is with iPolitics and Montreal Gazette. So you're getting some insight not only into the legal mind that we have right here in studio, but sort of the political think tank, the political mind of Martin as well in Montreal. So I'm going to urge you to pose your questions to us, and this is an opportunity to have them answered. In the meantime, let me go back to our guests on Facebook. John van der Zand, I want to thank you for your question. He wants to know, why were SNC executives not, or why has it taken so long to get to prosecution of the SNC executives? Why such a long delay? And it has been years. Lee, let me ask you.
Well, this type of criminal proceeding is possibly the most difficult to establish. First of all, we have events that are taking place in Libya, and that's where the offense is alleged to have occurred.
Offenses of $48 million in bribery and corruption.
The question of how do you get the testimony of witnesses, the recipients of bribes, the people who provided the alleged services that were considered to be bribed, all these things. Libya is not a country from which we can use the power of subpoena to compel witnesses to come forward. So from a prosecutorial perspective, it's very difficult. We're talking about combing through electronic messages, through GPS location of parties, circumstantial evidence. The entire case has to be built upon circumstantial evidence, and those are often the most difficult to prosecute. As a result, the investigation itself is going to be very meticulous and will take a very long time. Once you get to the prosecution, you have motions, you have issues of law that come up before the judge. Right now we have a judicial review application that's separate to the criminal proceeding, in which SNC is saying that the prosecutorial discretion was not properly exercised with respect to the failure to provide a DPA. So these types of legal issues can cause proceedings of this kind to drag on for years and years.
You getting a little impatient, Martin?
Impatient. Look, these things, as Lee says, take forever. I mean, the other mitigating factor, of course, is that Muammar Gaddafi is no longer with us. He's dead. But you know what's interesting, and just to sort of get away from the question a little bit and get back into DPAs, basically these charges were laid in 2015, and it's now 2019. Some have been found guilty. Pierre Duhaime, the CEO, he's been found guilty, more or less a slap on the wrist. A lot of the other people, one other executive was let go because of the Jordan decision. His trial took too long to get the proceedings took too long to get to trial. This kind of thing. What is very, very telling for me, though, is that in those 4 years, we've had the public prosecutor's office work on this file diligently and forthright, going forward. What is fascinating to me is that the public prosecutors basically said, in not giving the DPA to SNC-Lavalin, basically, in my opinion anyway, showed their hand and said they have an extremely, extremely strong case against SNC-Lavalin, and that they would rather not, in effect, plead out with the DPA. It sort of speaks volumes to the strength of the case that the public prosecutors has against SNC-Lavalin, that they wouldn't even consider that.
And I just want to stick with this one point as well, because people are talking about thousands of jobs being lost across the country if there is no remediation and SNC actually goes to court. But in that change in the law, which allows for DPAs, which is brand new to Canada, there is a segment that says that cannot be taken into account in the decision-making. Am I right?
That's right, and that's one of the consequences of this issue being brought to the public at this time, because that provision in the criminal code specifically states that the DPA cannot be granted, cannot be negotiated if the motivation is to save jobs in Quebec, for example, or elsewhere in Canada. And the public debate that has occurred and the statements that have been made by the government make it more difficult for a DPA even to be considered, because the Prime Minister and various other Liberal politicians have stated, well, we were doing this in order to help save jobs in Quebec. And that is part of the public record that could be used in evidence. You have to remember that a DPA has to be approved by a judge before it becomes effective. And so a judge cannot approve a DPA unless the evidence, all the circumstantial evidence for the DPA are brought before her or him. And in view of the public statement saying that the prime motivation for pursuing it was to assist this company
or to save
for economic reasons, it would make it very difficult for an argument to be made that a DPA should have been offered.
Let's go back to our viewers' questions, and this comes from Twitter. JW, I want to thank you for sending this. Do you guys remember when Michael Wernick took to the stand to testify? And he did that twice. Of course, that's what the opposition would like to see happen with Jody Wilson-Raybould, is for the former Attorney General to have a second go at answering questions, and that still we'll have to watch. But the question from Jay is the clerk of the Privy Council, Michael Wernick, supposed to be a political surrogate for the Prime Minister, or did Michael Wernick overstep his mandate? Now, keeping in mind, he's the top bureaucrat. Martin, your thoughts?
He's supposed to be the adult in the room, in the sense that everybody in the PMO, for example, the Prime Minister's office, sure, they're doing better, working in government, et cetera, but they're working in partisan government. They're there ultimately to protect the Prime Minister. The Privy Council, clerk of the Privy Council is not. He is there, as you said, he's the #1 bureaucrat in the country. And I think what took a lot of people off guard was the extent to which Mr. Wernick, defended this government, came out and said that, basically called the Globe and Mail piece on which all of this is based, basically saying that it was riddled with inaccuracies and was likely libelous, et cetera, that he almost overstepped that. And furthermore, there's testimony that Jody Wilson-Raybould said that he pressured her on behalf of Justin Trudeau, because Justin Trudeau specifically wanted that DPA or remediation agreement to become in effect with the SNC-Lavalin. So I think it's a very, very valid question, and I'm not the arbiter of whether or not he stepped over the apolitical line that he's supposed to toe, but it's more than I've ever seen a clerk of the Privy Council say in public in defense of the government.
And he seemed pretty forthright about his answers as well, as Michael said, or as Martin said, in defense of the government. Your thoughts on whether the clerk overstepped?
My thought is that he didn't. That his role as the chief civil servant in the country is to be non-partisan. So the question that you have to ask yourself is, if it were a Conservative or an NDP government that he was assisting, would he have said the same things in the same manner? And I don't read into any of his comments anything to say that he is supporting this government because it's a Liberal government.
And he has worked under each one of those stripes,
That's right. And what I would say is that as part of the machinery of government, it is very difficult, in fact, it's impossible to separate one's mind from being a supporter of the government. And you remember the British TV series, Yes Minister and Yes Prime Minister?
Yes, I sure do.
We had the equivalent of a Mr. Wernick in those instances, and their role is to support and to facilitate the government working in accordance with the duly elected public officials.
And to expedite that. Sorry,
I-
Martin, go ahead.
I take Lee's point on that, for sure, absolutely. The one area where I think he overstepped his bounds, and again, this is not legally binding, it's my personal opinion, was when he prefaced his remarks in the first set of testimony that he gave, where he talked about, as I mentioned before, the Globe and Mail story, saying that it was potentially live, was riddled with inaccuracies, et cetera, et cetera. Interestingly enough, everything that followed that statement basically reinforced what the Globe and Mail had said in that original piece on February 7th. Second of all, when someone calls out, that there's riddled with mistakes, I'm a journalist, so if I have write a story that is riddled with mistakes and that I've potentially libeled someone, I would expect that person to come out and request a retraction or at least a correction. No such retraction or correction was forthcoming from Mr. Wernick's office.
Okay, we just have time for a couple more questions, so I'm going to try to boot through so I can get Michael Marchand on. No relation, okay? But this does come from Michael on Facebook. Martin, Michael brings up the point, didn't the Liberals campaign on transparency? And yes, they did.
Oh,
so he says,
question.
how can a Liberal majority in committee, and he's talking about the Justice Committee, shut down any investigation or any committee, I suppose? I guess to rephrase that, where's the transparency is what Michael would be asking.
Michael, that is a great question, and it gets to exactly what the role of opposition is and how that role of opposition changes completely, I would say, hypocritically once you become in office. I'm going to read you a quote this is from Mark Garneau in 2011. Stephen Harper's arrogance and obsession with control and power has only gotten worse since he got his majority. The Conservatives are relying far too heavily on moving committees in camera whenever possible. That means Canadians are being shut out of discussions and laws that affect them and their families. Mark Garneau, who's today Transportation Minister, said that in 2011. Fast forward 8 years, that is exactly what his government is doing right now. And that goes to the core of this issue. And I think it's part of the reason why Justin Trudeau is suffering so much from this, is that not only is he sort of going back on his word and doing this, but he stated out, I was sitting 40 feet from him when he said it in 2015, that his government was going to be better. They were going to do better than all of this, than the previous government. And they're demonstrably doing exactly the same thing as the government before.
Transparency is one of those words that gets bandied about. It's we all use it, and it's a question of to what extent the Liberals are using it. Final question, perhaps this might be the final question. Maybe we have time for more. I don't know. We'll talk to my producer. Rachel Boucher asks on Facebook, and this I'm going to put to you, Lee, what does Jody Wilson-Raybould have to do in order to tell her story? Resign? Have a new by-election in her riding? So let me ask you this. If she resigns, does all that waiver, her client privilege waiver, does it all go away?
It's a burden that she has to carry. It's a burden that everybody in the position of an attorney, a lawyer of any kind, and she was in the position of a lawyer. If the privilege applies, then she doesn't have, I can't resign my license as a lawyer and decide to tell all the secrets of my clients. It's the same principle that applies.
I see. You know what? That makes complete sense to me now that I think about it. You are the keeper of secrets.
That's right.
Right?
Yeah.
And the reason why we keep secrets is so that we can advise clients to obey the law.
Exactly. And you probably know
all.
all.
Go against our advice, that's not a problem.
Martin, your thoughts on Jody Wilson-Raybould? Do you think she wants to talk? I mean, she has said she will come back to testify.
Yeah, I mean, she stated that she wanted to talk. I think what the Liberals have to worry about a little bit here, and it came up a little bit during her testimony right at the end when she was having that back and forth with Lisa Raitt. Lisa Raitt asked her, would you be willing to come back and testify on other matters up to and including possibly the Mark Norman trial on the East Coast? And I think that's exactly what the Liberals want to prevent. They don't want to have her come out and start speaking about things that go beyond this, because then it becomes less of a scandal just about SNC-Lavalin and a general lack of transparency and questions of obstruction of justice on the part of the government. On whether or not she has to resign and whether or not she'll run again, I think the Liberals have ensured that Jody Wilson-Raybould, regardless of this, she's a Liberal or not, is going to be a very, very popular candidate in her riding on the West Coast.
You guys have been fantastic panelists, and we've been taking our questions from our viewers, and I want to thank you on Twitter, on YouTube, on Facebook as well. But let me ask you this. This is your moment now. I'd like to know, is there a question that really burns for you that you would like to know the answer to, Lee, in all of this SNC controversy?
Well, I have to admit that it is a political one, and it's not my role to weigh into
Well, maybe you can ask Martin, huh?
That's right. Is that from my perspective, there is no evidence that a law has been broken.
You mean in terms of pressure, inappropriate or appropriate, whatever?
That's right,
yeah.
because the criminal code is specific. There has to be an attempt to obstruct, and attempt means something within the criminal code, and preparing to do something or wanting to do something does not constitute an offense. And so if there was no offense, and I presume that somebody took some legal advice that there was no offense, then why go through the political machination of denial in order to try to shut it down, when in fact if the position could have been, well, as our elected officials are required to pursue the protection of jobs, and that's the narrative that we're hearing, then why deny the story in the first place?
You know what? Jody Wilson-Raybould did testify, and she said that despite the pressure she felt, she did not believe what transpired was illegal, and that came from her own mouth when she testified on February 27th. Martin, I wish I could ask you what your burning question is, but we've run out of time, and that's great because, shucks, we've had our viewers in, and that's really the whole point of this. So I hope that you have enjoyed that interaction. I want to thank you as our panelists in Montreal, Martin Patriquin, author for iPolitics and the Montreal Gazette, right here in studio. We have lawyer Lee Akazaki, and I want to thank you. He is with Gilbertson Davis LLP. Have you enjoyed it?
Yes, I have.
Thanks a lot.
All right,
yeah,
Martin,
it's been a lot
you
of great
take
questions.
Care.
Thank
and
you.
Lee, thank you so much. For all of you who sent us questions on Facebook and YouTube and Twitter, it's great. It's great to hear from you. It's great to put a name to you. And I know I talk at you. Perhaps you use that term. I like to think I talk with you. But I know I talk at you every day from 10 to 1. And this is a chance where you get to come into our program, and it's great to have you. So my colleague Andrew Nichols will be answering more questions next hour. Stick around for that. This is CBC News Network.